Uh, and I'm going to move straight on now to a man who needs absolutely no introduction to this group, as its founding father, along with, or founding member, along with his wonderful wife, as a son of Western Australia, who seems almost literally to have come from the wrong side of the tracks and worked his way up to the very peaks of Australian society based on brilliance and diligence. I think Aristotle once said a man should be able to play the flute but not too well, or gentleman, sorry. So I don't know whether that makes you not a gentleman, John, because you seem to be so damned good at everything. My one comment I will share with you is that when I was the opinion editor of The Australian for 7 years, and some people have very kindly said they miss me at The Australian, and to the extent that they do, I'm sure it's because I haven't seen John on those pages as much as he deserves. The Australian's loss has been the Spectator's gain, where he's become a champion for the so-called Delcons, although I don't think anybody nowadays is arguing there's anything delusional about those conservatives. So that's right, they're discons, the discontented conservatives. So without further ado, please welcome John Stone on Enough is Enough.
Whose does all that belong to? Thank you very much indeed, Rebecca, for that overgenerous introduction. Okay. How am I audible up the back? Good. Well, I'm beginning with a welcome to country. A welcome to our country. So let me begin by acknowledging the traditional owners of this land, King George III and his heirs and assigns. Now, I'm giving this paper because, having observed Aboriginal politics for the past 50 years, it's time to say it's over. Our once seemingly boundless goodwill towards our Aboriginal fellow Australians is becoming exhausted. Despite the countless billions spent in their behalf, each failed program is succeeded by demands for another. Aboriginal demands fatigue is setting in. Recent developments have been the last straw, and the resulting referendum council, been the last straw. The so-called Uluru Statement of the Heart, read pocket, and the resulting referendum council power grab proposals, which, if ever consummated, would threaten not only the workings of our representative democracy, but also the very sovereignty of the Australian nation. Enough is enough. So I'll briefly set out how I propose to frame this paper. I begin with the 1967 Constitutional Referendum. In hindsight, that can now be seen to have committed the fatal error of handing power over Aboriginal affairs to Canberra. During the next 25 years, federal governments of both political persuasions pursued broadly similar and broadly equally mistaken policies. The next milestone is the High Court's 1992 decision in Mabo, when 6 out of 7 justices delivered what clearly ranks as the most legally indefensible decision in that court's history. The Keating government then enlarged upon that damage via the Native Title Act, 1993. After that, we had the National Inquiry into the separation of Aboriginal and Torres Strait Island children from their families, which in 1997 produced its Bringing Them Home report, inventing the still extant myth of the stolen generation. In 1999, the Howard government sought to amend the preamble to our Constitution, which was the first significant step in what has since become the Recognition Project. The stolen generation myth was revisited in 2008 with a national apology in Parliament by Kevin Rudd, echoed by the equally deluded Brendan Nelson. The Recognition Project was formally initiated in 2010 by the Gillard government, appointing, as has been just said, a so-called expert panel to consider that matter and make recommendations. And thereafter, we've had a series of such bodies appointed by successive governments, recently culminating in the proposal for a constitutional provision establishing a special Aboriginal body sitting alongside our already representative Parliament and empowered to give advice on what would quickly become almost all Commonwealth legislation. So I start in 1967. I was then living in Washington, DC. I'm not even sure I voted, but if I did, I'd probably have voted yes. Many years later, my old friend, the late Ray Evans, told me he had firmly voted no, because giving more power to Canberra was always a bad idea. How wise he was. Now, the referendum sought to amend Section 51(26) of the Constitution, in which the words, "other than the Aboriginal race in any state," those words excluded the federal parliament from making special laws for Aborigines other than its own territories. The almost 91% referendum vote to delete those words reflected a widespread attitude of goodwill towards Aborigines. Today, however, it's notable that Aboriginal industry spokespeople normally revile the amendment, saying it hadn't done anything for us, and that, they argue, the federal parliament has used it to make special laws against Aboriginal interests. The example in that respect being most often quoted is the Howard government's intervention to deal with the endemic sexual and other abuse of Aboriginal children revealed by the Northern Territory's Little Children Are Sacred report in 2007. As for the complaint that the 67 Amendment hasn't done anything for us, that reflects both the lies told in the lead-up to the referendum by its proponents, which raised false expectations, and the continuing reality that inserting words in the constitutional rulebook is no substitute for what John Howard was later to call practical reconciliation, namely measures to improve Aboriginal health, education, and so on. Well, the following 25 years saw governments of both political persuasions stumbling from one failed policy to the next. Began with Harold Holt's appointment of Nugget Coombs as chairman of a Council of Aboriginal Affairs, where he embarked on a 30-year personal project to destroy our national sovereignty. It ended with the Hawke government establishment, with unanimous cross-party support, I should say, of the Council for Aboriginal Reconciliation. During the intervening years, we saw a cavalcade of Aboriginal bodies established and replaced. We had the National Aboriginal Consultative Committee, the Department of Aboriginal Affairs, the National Aboriginal Conference, the Aboriginal Development Commission, and the Aboriginal and Torres Strait Islander Commission, ATSIC, in 1990. But throughout these 25 years of perpetual change, three things remained unchanging. The constant flow of money, at first a trickle, building to a river, within which the Aboriginal industry has its being. The fact that despite the money lavished upon them, the situation of what I call real Aborigines does not seem to have improved, and the fact that as each demand has been granted, has been succeeded by a new one. So we come to Mabo. The High Court's 1992 judgment was in fact Mabo number 2, which had originated in a High Court action brought in 1982 by Eddie Mabo, himself a Meriam Islander, claiming title to land on Murray Island. Despite a finding, meanwhile, by Queensland Supreme Court Justice Moynihan that made it clear that Eddie Mabo was not in fact a witness of truth, the High Court proceeded to hear the legal arguments. Now, in a paper to this society in the following year, 1993, the late S.E.K. Hume QC scarified the judgments of the 6 perpetrators of the Mabo judgment. In brief, he said, the court was hearing a case about land holdings in the Meriam Islands, out there in Torres Strait. Whatever the merits of that case, on which Justice Moynihan had already raised the gravest doubts, evidence led in support of it had nothing to do with mainland Aborigines and ethnically and culturally distinct people. Next, at no time throughout was any evidence led bearing on the mainland. Statements by at least 2 of the justices, Dean and Gaudron, revealed that their joint judgment had been influenced by the writings of historian, if you can call him that, Henry Reynolds, even though those writings were not before the court and were therefore unable to be challenged. And finally, Sec Hume said, in its dealings with the terra nullius doctrine, the court simply fell into error. In summing up, he said, with no mainland issue, with no evidence as to the mainland, with no parties concerned with any mainland issue, without argument as to any mainland issue, the High Court proceeded to destroy what Dean and Gaudron, JJ, described as a basis of the real property law of this country for more than 150 years. In an address launching the first volume of our proceedings, the late Roddy Marr, at the time an outstanding justice of the Court of Appeal of New South Wales, said, I quote, "In the Mabo case, the judgment of Brennan J. said there were two ways of approaching the question of whether the natives in question owned the land in question. One way was to apply the existing legal authorities. But His Honour spurned such an approach and thought it more plausible to invent a new law." Finally, and I find this particularly troubling, was the claim by the perpetrators of this judicial outrage that the case was decided as a matter of common law. Now, the common law, as everyone in this room knows, comprising the accretion of judge-made decisions as opposed to statutory law based on legislation enacted by parliaments, is by definition a body of law built up slowly over time by small alterations to previous judgments. In its very nature, it has never, in any national jurisdiction in which it prevails, involved revolutionary change. Yet in Mabo No. 2, 6 justices of our High Court not only effected a revolution in our settled property law, but subsequently also had the effrontery to describe that judgment as a common law decision. From that day onwards, those 6 justices and the High Court, I'm not referring to the individuals on the High Court, the High Court as an institution have been widely held in contempt. Which brings me now to the Native Title Act 1993. Now, since Mabo No. 2 was not decided on constitutional grounds, it would have been open to the Keating government to legislate to overrule the court's decision and the court's destruction of our previously settled property law. Instead, it doubled down on the court's behaviour by enacting the Native Title Act 1993, which rendered the new form of title a much more serious threat to Australia's future well-being than the original form invented by the court. In particular, by providing Aboriginal holders of native title to a land holding with a right to negotiate, those are the key words, with anyone that wanted to come onto that land to do business, it ushered in a governmentally condoned form of blackmail and officially sanctioned extortion. 4 years after Mabo No. 2, the High Court was confronted with another almost equally important decision in the Wick case, when the Wick people claimed native title over a property held under pastoral leasehold title. Now, the Mabo decision had made it clear that once Crown land had been alienated by granting it as freehold, native title was extinguished. And it was understood this also applied to alienation via grants of leasehold. Indeed, during the passage of the Native Title Act 1993 through the Parliament, Paul Keating had unequivocally assured the nation to that effect. However, in Wick, the court now found otherwise. The shock of this decision reverberated throughout the pastoral industry and beyond. But this time, however, the situation differed from 1992. John Howard had meanwhile become Prime Minister. Unlike Keating, who had moved to make things even worse than the court had, Howard moved to overturn Wick. By enacting the Native Title Act Amendment Act 1998, his government, while not completely reversing Wick, at least mitigated most or many of its worst effects. The next marker in this long and painful saga is the Stolen Generation myth. Now, there had long been claims that earlier state government authorities had removed Aboriginal children from their parent or parents against the latter's will, and that these removals originated in racist motivations. We saw this on the part of His Honour, I think he's the Chief Justice of this state, yesterday. In 1995, the Keating government set up the National Inquiry into the separation of Aboriginal and Torres Strait Island children from their families, which was chaired by the head, or then head, of the Human Rights and Equal Opportunity Commission, Sir Ronald Wilson QC. He was assisted by his own Aboriginal Social Justice Commissioner, Mick Dodson. To say that this inquiry's report, Bringing Them Home, was called, was a travesty would overrate it. to say that a former High Court Justice, which Sir Ronald Wilson had been, could lend his name to the processes involved, his name and his authority, and the recommendation flowing from them would normally invite disbelief. During a 17-month inquiry, Wilson and Dodson heard what they loosely described as testimony from 535 Aborigines. Their report described the process whereby Aboriginal children were taken from their parents and put in white foster homes as, quote, genocide, unquote. So, as distinct from this pack of lies, what were the facts? Here are a few of them. Wilson and Dodson made no attempt to check the veracity of this testimony of those 535 Aborigines, and those responsible for the alleged thefts were given no opportunity to defend their reputations. Subsequent court cases brought by Aborigines to establish their stolen status have all resulted, except in one case, which I'll come to, in their claims being dismissed as groundless. Since those behind bringing these claims would certainly have chosen those most likely to succeed, the others clearly had even less foundation. In the one case where the claim was upheld, the boy in question was not originally stolen, in quotes, but brought to an Adelaide hospital for treatment. When the parents never reclaimed him, and efforts to locate them had failed, a nurse, the hospital, arranged for a state authority to place him with a foster family. There he grew up in what he later described as a happy relationship with his non-Aboriginal foster parents. Nevertheless, the court found he had been stolen and awarded sufficient compensation, it ran to more than $500,000 if I recall correctly, to atone for the error of giving him a happy life. On all this question of removal of Aboriginal children from their parents, Keith Windschuttle's magisterial work, The Fabrication of Aboriginal History, which to anyone interested in this subject I tell you is absolutely required reading, shows that in every case cited, the reasons involved protecting the child from the dangers to it in its Aboriginal community. And if you want any further proof of the nonsense talked in this area, the number of Aboriginal children being removed each year today from their Aboriginal parents to protect them from physical, including sexual, abuse actually exceeds the earlier annual numbers. And that's despite the authorities' extreme reluctance to take such action for fear of being again accused of stealing these children. However, despite animadversions such as these, the intellectual poverty of the stolen generation myth, it has remained firmly entrenched in the national consciousness. In fact, the only bright spot in the 20 years since the report was delivered was that despite unremitting pressure to do so, John Howard refused to make any national apology. However, in 1999, John Howard, now moving on, was persuaded by Noel Pearson that the preamble to our Constitution should be amended to mention our original inhabitants, and this proposal was put to a referendum concurrently with the one for making Australia a republic. Now, you'll remember that the conflagration that consumed the latter, that's the republic proposal, was severe enough. But it was as nothing to the inferno that devoured the preamble proposal, with a national no vote of just over 60% recorded. Not only was it rejected in every state in the Northern Territory, but mirabile dictu, even in the ACT. We're coming back now to the stolen generation. On 13 February 2008, Kevin Rudd delivered to Parliament a national apology for the stolen generation. In a Quadrant article a couple of months later, which I called Time to Stop the Dreaming, I said that Rudd's apology, quote, fully accepts, without question, the tissue of lies, half-truths and evasions that constituted the Bringing Them Home report. The statement also parades as fact one untruth after another. This massive lie, now publicly sponsored by no less than our Prime Minister, will now be recycled over and over again with a stamp of his authority upon it. End of quote. Rudd's national apology was built around those same elements which time after time have characterised the Aboriginal industry over the past 50 years. First, historical fabrication. Secondly, street theatre. Thirdly, demands for money under the pretext of, quote, compensation for historically untruthful wrongs. And finally, evasion of the real problems besetting Australian Aboriginality, which stem from the very nature of Aboriginal culture itself. All of which brings us to the recognition project, of which we've already heard from Keith in this very fine paper. In 1991, the Hawke government had enacted the Council for Aboriginal Reconciliation Act 1991, under which was established the Council for Aboriginal Reconciliation. 10 years later, that council established a new body, a privately incorporated body, in fact, Reconciliation Australia, which pursues a bewildering array of initiatives and programs in workplaces, schools, AFL grounds, Aboriginal communities, and organises annually a so-called National Reconciliation Week. Chief among its activities has been the Recognise campaign, aimed at boosting support among Australians for recognising Aboriginal and Torres Strait Islander peoples in the Constitution. Now, in my written paper, I describe the long drawn-out successive moves by governments of both political persuasions towards a referendum to amend our Constitution in that regard. And time constraints here mean that I merely mention, first, Julia Gillard's proposal to that effect in November 2010, the work of her expert panel, on which Keith spoke at some length, reporting in January 2012, her establishment of a Parliamentary Joint Select Committee to pursue the matter further, November 2012, enactment with bipartisan support of the Aboriginal and Torres Strait Islander People's Protection Act 2013, which affirmed Parliament's, quote, support for constitutional recognition, unquote, which is March 2013. That Act's initiation of a review to, quote, consider the readiness of the Australian public to support any such referendum, March 2014. The report of that review in September 2014, suggesting, incidentally, that the project was losing momentum. And the final report of the Joint Select Committee in June 2015, and finally, establishment of the Referendum Council, to which I now come. On 7 December 2015, Malcolm Turnbull and Bill Shorten announced appointment of the Referendum Council, co-chaired by Patricia Anderson and Mark Liebler, AC, whose duty was to consult widely throughout Australia and take the next steps towards achieving constitutional recognition, etc., of the first Australians. That's the first time I think I saw that phrase appear in this literature. By the way, these terms, the First Nations and First Australians, they're simply United Nations derived terms from the UN, I guess the UN Treaty on the Rights of Indigenous Peoples. And like so much in this area, it's derivative stuff. The Council first issued a discussion paper. 6 months of meetings then ensued, which Keith told us about, of various mainly Aboriginal groups around Australia, all at taxpayers' expense. And these meetings, among other things, elected delegates to attend what was called a First Nations, there you go again, National Constitutional Convention at what I still call Ayers Rock in May 2017. Meanwhile, however, Noel Pearson, aided and abetted, I'm sorry to say, by two members of the Society, Julian Leeser MP and Dr. Damien Freeman, had produced the concept of a new constitutionally entrenched Aboriginal advisory body. Advisory is in quotes, to sit alongside Parliament and with the right to advise on any legislation it might consider affected Aborigines. I mean, all principles apart, consider the procedural nightmares resulting from any such arrangement. And I have to say, the kindest word to describe it is ridiculous, but it's worse than ridiculous. It's very, very dangerous. I spoke a little while ago about the particular importance within the Native Title Act 1993 of the so-called right to negotiate, which is a license to blackmail, or if you like, as I said, I think condonement of officially condoned extortion. Just imagine the potentialities for blackmail inherent in the establishment of this body. Oh yeah, we could maybe go along with it if by some reason there was some little handout to some of us or some body of ours along the way. We could arrange that if you felt you really needed it, Prime Minister, but otherwise we're against it. It'll be right to negotiate on steroids. Nevertheless, when those 250 well-fed Aboriginal delegates foregathered at Ayers Rock, this proposal was to figure centrally in their demands, as has been pointed out. Those demands now emerged in a so-called Statement from the Heart, the Uluru Statement from the Heart, and in a media release made on behalf by Patricia Anderson, quote, on behalf of the Referendum Council and Indigenous Steering Committee. on 26 May this year. Both documents voiced numerous emotional assertions along with three substantial proposals. Keith's spoken about the three substantial proposals, so I won't come to them now. But consider some of those emotional assertions in both those documents. There's first the claim that, quote, Aboriginal tribes were the first sovereign nations of the Australian continent. Now, while nobody disputes Aboriginal habitation of our continent prior to European settlement, describing those tribes as sovereign nations is nonsensical. In no other word to describe it, nonsensical. Sovereignty connotes ownership, and mere occupation is not ownership. Ownership comes from settlement, and there was never any settlement by Aboriginal nomadic tribes. Settlement connotes, among other things, agriculture. At a Stone Age, hunter-gatherer people didn't have any agriculture, unlike the Miriam Islanders, I might say. Indeed, the statement itself admits, and I'm quoting now, that this sovereignty is a spiritual notion, that is not a legal one. Claims that this so-called sovereignty, quote, had never been ceded or extinguished and coexist with the sovereignty of the Crown are simply piffle. Were this sovereignty claim not so sinister, it would be laughable. Next, we are told that Aborigines, quote, are the most incarcerated people on the planet. That, quote, our children are alienated from their families at unprecedented rates. And, quote, our youth languish in detention in obscene numbers. Now, these statements are broadly true, but the questions they invite have nothing to do with our oppression of our fellow Aboriginal fellow Australians and everything to do with the latter's own behaviour, including in particular behaviour towards their own children. Report on that latter point, report after report over the years, Bonnie Robertson, all these people, have spelled out the relevant facts in invariably agonising, and I mean agonising detail. To say that, quote, as the statement goes on, to say that, quote, when we have power over our destiny, our children will flourish, simply invite derision. And to add that, then, quote, their culture will be a gift to this country, unquote, when it is that same violent and payback-ridden culture that is at the root of the evils previously enumerated, has the same smell about it. If ever there were a case of physician heal thyself, this is it. Now, as for the demand for, quote, truth-telling about Aboriginal people's history, will that truth-telling serve to correct all the lies we've been told about extensive massacres, frontier warfare, stolen generations, the romanticised dream time, and so on, to which our children and grandchildren continue to be subjected? And the statement concludes with this rhetorical flourish. It says, in 1967 we were counted, in 2017 we seek to be heard. We seek to be heard. Now, am I the only person already half deafened by the past 50-year cacophony of complaint? Now, what's been the response to this Uluru statement? All I can say to begin with is, to judge by the sharply divided responses to it, public controversy over them will make the Republic debate seem harmonious. Take a few in support to begin with. The Australian particularly. We quickly saw supportive articles from, among others, Paul Kelly, who said that the statement, quote, deserves a respect and evaluation by the political classes befitting its seriousness. Immediate rejection, Paul said, betrays contempt for diligence, realism and revisionism this document embodies. Now, that's absurd. While as for describing these fantasies as realism, I must be using a different dictionary. According to Kelly's article, Julian Leeser MP has called the Uluru Statement the big breakthrough, saying that, quote, looking at the structures of government and offering a voice in policy making reflected the thinking of Griffith and Barton and their colleagues who framed the Constitution had they turned their minds to this issue, unquote. Now, if I may say so, with not too undue disrespect to Julian Leeser, that statement displays the same disrespect for the reputations of those no longer present to defend themselves as the notorious suggestion during the Republic campaign that had Sir Robert Menzies still been alive at that time, he would have been voting yes. In reply to a Greg Sheridan article which had urged the Liberals to join Barnaby Joyce's Uluru rejection, which I'll come to in a moment, Noel Pearson launched a venomous, and it was venomous, ad hominem attack on Sheridan, describing his article, Sheridan's article that is, as appalling commentary and offensive and obscurant. Pearson alleged that, quote, his contempt for Aborigines is palpable and nauseating. There was more, but you get the drift. Now, it may be, by way of an aside, appropriate here to note that Pearson has serious form in this personal abuse stakes. In 1996, he described John Howard's government as racist scum. In 2014, then senior Sydney Morning Herald journalist Paul Sheehan detailed incident after incident when Pearson had delivered foul-mouthed tirades where he, quote, dropped the C-bomb, unquote, often coupled with a racist epithet. There were, however, some critical responses. I've already mentioned one of them, and it was an important response because it came very quickly and was made by Barnaby Joyce, the leader of the Labour Party. Well, I could almost say so, couldn't you? The leader of the National Party, who said the proposal for a constitutionally enshrined body to influence policy in Canberra was not going to fly. Those were his words. The leader of the Australian Conservatives Party, Senator Cory Bernardi, went further on the 31st of May, describing the Uluru demands as being so divorced from reality, one might almost think the people behind this process actually want any referendum to fail. Put simply, we need to deal with the issues today, not continually revisit the problems of the past. Greg Sheridan began his article, the one subsequently attacked by Pearson, by praising the, quote, common sense and good instincts of Barnaby Joyce, whose, quote, straightforward rejection of the recommendation of the Uluru Gathering ought to put the matter to rest. The Aboriginal leadership, he said, over the past 10 years has taken a terrible wrong turn in seeing continuing political and constitutional change as the main engine for advancement of Indigenous people. All the proposals emanating from Uluru, quote, are wrong in principle and would be profoundly damaging in practice, unquote. My own published criticism in The Spectator, which was called, I think, the recognition racket, first acknowledged that, quote, one worthwhile point did emerge from last Friday's statement, namely its dismissal of the so-called minimalist proposals advanced by such gullible, in this context gullible, people as John Howard, Tony Abbott, and originally Bill Shorten. As to the proposed constitutional provision, the one that's the centre of debate now, proposed constitutional provision, I asked, quote, has there ever been a more arrogant proposal? The only one, in my recollection, that even begins to approach it was that by the Vernon Committee in 1965, who recommended the setting up of an Economic Advisory Council. As Sir Robert Menzies said when comprehensively dismissing that recommendation, quote, the power to advise is the power to coerce. The bottom line, I said, is this: we are all Australians. We are not, we never should become first Australians and second Australians. There were, I should add, several prominent Aboriginal voices raised against some or all of the Uluru Statement. Of these, the most significant was that of Warren Mundine, who on 30th of May issued a lengthy analysis. He supported a Makarrata Commission to initiate and supervise making treaties, quote, between governments and First Nation groups, but disagreeing strongly with a proposal for a First Nations voice enshrined in the Constitution. On that he said, quote, I've always disagreed with this proposal and still do. Every Australian law impacts Indigenous people. Why should Indigenous people have a constitutional voice that other Australians don't have on laws that affect everyone? There's the no case right there. Absolutely right. So, in the aftermath to Uluru, there have been two developments. As was noted, on the 30th of June, Anderson and Liebler presented the final report of the Referendum Council to the Prime Minister and the Leader of the Opposition. It recommended, quote, that a referendum be held to provide in the Australian Constitution for a representative body, etc., 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 and for a declaration, etc., etc., etc. The Council described these consensus recommendations as, quote, modest, reasonable, unifying, and capable of attracting the necessary support of the Australian people. All four claims are, of course, groundless. One council member, former Minister for Indigenous Affairs Amanda Vanstone, did lodge what she called a qualifying statement, in which, while maintaining sympathy for Aboriginal aspirations for appropriate constitutional recognition, she said quite flatly that at this time these, quote, relatively new proposals would be unlikely to command support in a referendum. I've already really stated my view about these proposals, I won't repeat them. But early this month, both Turnbull and Shorten attended the annual Garma Festival in Arnhem Land, where they were asked to respond to the Referendum Council's report. Turnbull's response was characteristically temporising. rather than say flatly what he knows or should know to be the truth, namely that there is no way in which the Australian electorate will ever support such a referendum proposal, he lamely spoke of needing more time to give it careful consideration. In short, weasel words and waffle. Shorten, by contrast, could hardly have been more reckless. Quote, "We support a declaration by all parliaments. We support a truth-telling commission. We are not confronted by the notion of treaties with our first assembly, as first Australians." Unquote. So incredible though it may seem from one currently expecting to become Prime Minister, the Leader of the Opposition committed his party hook, line and sinker to the Referendum Council's power grab. Poor fellow, my country. So my conclusions are: the 1967 referendum outcome, reflecting the then enormous fund of goodwill towards our Aboriginal fellow Australians, was nevertheless a mistake, allowing Canberra to take power in a jurisdiction where its policies since that time have ranged between failure and disaster. The Mabo No. 2 High Court judgment clearly ranks, as I said before, as the most legally indefensible decision in that court's history. It has a few competitors, I should say, but nevertheless. Paul Keating's Native Title Act 1993, despite John Howard's Native Title Act Amendment Act 1998, rectifying some of the worst features, has nonetheless proved a millstone around the necks of business corporations, particularly but not only in the mining industry, seeking to pursue potentially profitable enterprises. The opportunity cost to our economy in terms of projects either delayed, abandoned, or never even initiated because they were thought to have little chance of succeeding is literally incalculable. But if I were to name a figure of $100 billion, that would almost certainly be conservative. Moreover, by end March last year, that Act, the Native Title Act, had led already to 30.4% of our continent being covered by native titles, both exclusive and non-exclusive, and with a further 31.7% of the area under claim and thought likely by experienced observers, thought likely to be mostly granted. Despite the countless millions of dollars showered upon our Aboriginal population over the past 50 years, there is little to show by way of improvements to the real problems in such fields as health, education, domestic violence, and above all, care for children. One of the few things I agreed with Mr. Justice Martin's comments yesterday, when he pointed out, I think, in that list of 8 closing the gap matters, that only one was showing any improvement, and even that he was on unsound ground because he got his statistics wrong, but that's another question. Next, there never was anything that could truthfully be called a stolen generation, and the only consequence of assorted politicians' apologies for it has been to provide a basis for yet another demand for money. The recent proposal to constitutionally entrench what would become a second House of Review alongside our Parliament is nothing less than a naked grab for power and worse. The proposal for a Makarrata Commission to supervise treaty making with so-called First Nations should be dismissed out of hand. Nobody disputes that Aboriginal tribes inhabited our continent prior to European settlement. However, those nomadic Stone Age tribes never had any claim to sovereignty over what we now know as the Australian nation. Trumped-up claims to sovereignty, such as those in the recent Referendum Council report, should be flatly rejected. Attempts to separate Australians into 2 categories, first Australians and second Australians, should also be flatly rejected. We are all Australians. We can't say that too often and too loudly. I finish where I began. This 50-year-long Aboriginal industry, denigration of Australia and denigration of non-Aboriginal Australians, and the depressing culture of Aboriginal complaint that it has fostered must end. Enough is enough.